Everybody. All right, can you let's settle down? All right, and we're still going to have people coming in. I'm Jenny Green. I teach here at the law school, the Human Rights Litigation and Advocacy Clinic and Business and Human Rights. And I am really thrilled to be able to introduce this panel. It's be a wonderful discussion to wind up with, going from the conceptualization, advocacy coming ground up from arguing about apartheid, gender apartheid, and its status in international law, and then also talking about the campaign and using multiple international forum in developing that norm. So first, I'd like to introduce the speakers. Karima Banoun is the Leo Symes Professor of Law at the University of Michigan Law School. And she served as the Special Rapporteur, United Nations Special Rapporteur in the field of cultural rights from 2015 to 2021. She's also an expert, was appointed as an expert for the International Criminal Court in 2017 on reparations involving heritage sites by extremists in Mali. She's also been a former legal advisor for Amnesty International and has carried out human rights missions in most regions of the world and has been on 3 missions to Afghanistan, visiting different regions of the country in 1995, 2005, and 2011, and has worked closely with Afghan women running human rights defenders, with Afghan women human rights defenders for many years, including during the 2021 evacuations. She's the author of International Obligation to Counter Gender Apartheid in Afghanistan, which appeared in the Columbia Human Rights Law Review in December 2022. And that's been translated into Farsi by the Afghanistan Institute for Strategic Studies. In September 2023, she spoke to the UN Security Council about gender apartheid in Afghanistan. And she's also traveled to South Africa with Malala Yousafzai to take place in a panel on gender apartheid with the Nobel laureate after her 2023 Nelson Mandela lecture. And she's currently vice president of the American Society of International Law. Alisa Yamamoto, who is an international human rights lawyer. I was going to say first, she's been a fellow here at the Human Rights Center, so but she's also serving as the senior legal and policy advisor at the Atlantic Council's Strategic Litigation Project, a think tank initiative that works on prevention and accountability efforts for atrocity crimes and gross human rights violations. She's also a legal advisor with the End Gender Apartheid campaign, global campaign to codify gender apartheid as a crime against humanity. She's served as a legal advisor to see if you can name this person, the UN Special Rapporteur on the Promotion and Protection of Human Rights while Countering Terrorism, our very own Professor Neil, and an attorney at an international law firm where she specialized in public international and international law and international dispute resolution. And, all the other qualifications of our wonderful speakers are in the program. So thank you very much. I'll turn it over to Corinne.
Thank you so much for that very kind introduction. It's really wonderful to be here. I'm battling allergies, so bear with me, but I'm armed with cough drops and water, so I think I'll be fine. Thank you for inviting me to this very important and timely event. And I wanted to say really what a profound honor it is to be here in Minneapolis, where I think a lot of people share traits in common with some of the Afghan women human rights defenders I'm going to be speaking about in a moment, including resilience and relentless creativity in opposition to systemic oppression. So it's very meaningful for me to have the chance to give this talk here. And today, what I want to focus on in particular is how the international community might collectively respond to what the former German foreign minister, Annalena Baerbock, who's now president of the UN General Assembly, has called the biggest violation of women's rights on earth, by which she meant the situation of Afghan women and girls under ever more draconian Taliban rule. And I'm going to focus in detail on the emerging international legal prohibition of gender apartheid and how central I believe it is to addressing the situation of women and girls in Afghanistan in particular, though, and we can discuss this of course also has relevance for other contexts. And here is what I'm going to try to address in my time, looking at the context in Afghanistan, some of the history and meaning of the concept of gender apartheid, what I believe to be its added value, which responds to an issue that was raised in the first session this morning, and then concluding with the way forward before handing over to my distinguished colleague, Elisa Yamamoto, who will talk about a very important part of that way forward, specifically the possibilities for codifying gender apartheid. So let me start by talking about the situation in Afghanistan. And I want to say quickly that I know many of us are also gravely concerned about other situations facing women in other contexts, whether it's Lebanon or Gaza or Iran or many others that one could think about. And I had the honor, as Professor Green mentioned, of traveling with Malala Yousafzai when she gave the Nelson Mandela lecture in December 2023. And she said something very important. She said, we cannot allow ourselves to buy into this false notion that we can only care about one crisis at a time. We have to be able to hold space for suffering wherever it is happening in the world. So just as she did, I want to shine light on the situation of women in Afghanistan, but in the broader global context about which I too am deeply concerned. But I really fear that the Afghanistan situation has disappeared off our TV screens, and this erasure has very grave consequences for the nearly 20 million women still in Afghanistan. It also has implications for the fight for women's rights literally everywhere. So let's talk about this situation in Afghanistan. And here you see some artwork by Afghan girls who unfortunately have to be anonymous that was collected by the wonderful Afghan organization, the Art Lords. And I think the picture describes perhaps better than I can with words the situation that women and girls are facing. And I always say this, I think the best way maybe to explain this situation would be for me to be silent. You may wonder, why is that the case? Well, one of the things the Taliban have done is to ban women from speaking in public, to ban women from speaking to each other in a range of ways. And of course, Afghan women immediately did the best they could to defy those restrictions through a very brave campaign of clandestine singing, sometimes on the internet, sometimes even in public. And so they obviously are really the leaders in exposing what they are facing and in pushing back, but they are in need of grave need, of global solidarity and support. So the restrictions I just mentioned are, of course, just a few examples of what the Taliban have done to women's rights. They have passed, and the numbers are sometimes sort of controversial and debated, but they have passed at least 139 decrees that have stripped Afghan women of most of their human rights. This includes the rights to education, to work, to health, to freedom of movement, and to take part in cultural, political, or social life really at all. And what is particularly shocking is that the Taliban have done all of this openly. They have never disputed that they've done this, and they've done it in ways that could be described as de jure, in plain view of the entire world. So the way the world responds to this then has very significant consequences. Meanwhile, the Taliban have also systematically destroyed the legal and institutional framework underpinning women's rights that was built by women human rights defenders over many years, including the Taliban have abolished the Ministry of Women's Affairs, they've abolished the Afghan Independent Human Rights Commission, and they have beaten and arbitrarily detained and tortured some of the women human rights defenders who resist these apartheid restrictions. So what we see looking at this, the totality of this, is that their rule represents the antithesis of the UN Charter. And the question then is, how is the international community going to respond? How is the UN going to respond? The consequences for women on the ground are so grave. And I will just illustrate this with one fact. There are many one could cite to, but that fact is the increase in reports of suicides among Afghan women. And that started to be reported in about the summer of 2023 and continues to be reported. It's a really horrible, but unfortunately predictable consequence of the current situation. Imagine losing your ability to work, losing your ability to study. Imagine being told, if at all possible, you shouldn't leave the house at all. Imagine being told you're not worthy of going to the national parks of this country. Imagine being told you can't participate in sports. Wouldn't you demand a truly exceptional response to denials of rights like that? Some of the most recent denials include even banning women from studying midwifery and nursing. This relates very much to the topic of the last panel. And if you combine that with restrictions on women healthcare workers working and women receiving healthcare from male healthcare workers, I mean, this becomes a very dire situation indeed. Meanwhile, unfortunately, we see an international community that is forgetting the situation in Afghanistan, that in some areas is actually moving to normalize the Taliban, despite this really grim record. We see some recognitions of the Taliban by some governments, even handing over of embassies of Afghanistan to the Taliban. And I was shocked when I attended a Security Council meeting in 2025 about the situation in the country to see major countries like China, Russia, Pakistan, all calling very openly for the normalization of the Taliban while this group is erasing half of the population of the country. And I think this has terrible consequences, first and foremost for Afghans, but it actually undermines the entire framework that protects women's human rights everywhere. So it's really a test for the international community and certainly for human rights experts. The question then becomes, how can we ensure that Afghan women have all the tools they need to successfully challenge Taliban abuses? What kind of international legal solidarity with them is useful at this stage? And that brings me really to this concept of gender apartheid. Because the question is, to quote Tolstoy, what then must we do? How do we tackle this kind of oppression of women? How do we support those who are leading the effort to do so? And that brings me to this concept of gender apartheid, which has been at the center of my work in the last few years. And you see here the Farsi translation of the cover of the translation of my article on gender apartheid. And I have a few copies of the English version, if anybody's interested. It's very long. It's about close to 100 pages long. But I was really moved by this cover because you see literally sort of this erasure of a young woman exemplifying what gender apartheid is doing. So back in 2022, I published an article called The International Obligation to Counter Gender Apartheid in Afghanistan. I was really honored that it was translated into Farsi. And what I was looking for was basically heightened international legal responses to the situation that Afghan women are facing after the fall of their country to the Taliban again. And in particular, responses that meant the international community could not simply walk away from its responsibilities because they had physically left the country. So the point was to galvanize a new, comprehensive, human rights-based response that could pressure the Taliban, but also could pressure the international community to not respond to the Taliban in ways that end up being complicit with their practices. And my article was written in consultation with diverse Afghan women human rights defenders. This was very important. Interviews with them are incorporated into the paper. And it was really noteworthy to me that almost all of the Afghan women advocates I interviewed back in 2021 and 2022 already agreed with the characterization of the country's situation as gender apartheid. And of course, as we know, things have only gotten worse since then. So what then is gender apartheid? In my article, I describe it as, and I think this is very important, a system of governance based on laws and or policies, which imposes systematic segregation on women and may also systematically exclude women from public spaces and spheres. It's a kind of systemic oppression of women, treating them, as one of the Afghans I interviewed said, as being, quote, not as human as men. Think about that, not as human as men. Now, women's rights advocates have used this concept to describe the systems they battle in a range of contexts in Iran, in Yemen, in Saudi Arabia, and in Israel in the context of the rise of ultra-Orthodox Judaism. But I would say that Taliban Afghanistan is really the paradigmatic example of gender apartheid. And this concept is adapted from the international law on racial apartheid so as to emphasize that discrimination against women has been made the system of governance itself. And so there's discrimination against women, unfortunately, that persists everywhere in the world, but this is very distinctive in terms of its scale and its systematicity and its institutionalization. So we can then put this into a legal definition that I think Elisa will talk about in more detail, so I won't say too much about this. But basically, if you add gender alongside race in the definition of apartheid that we have from the Rome Statute of the International Criminal Court, then you end up with a legalistic definition of gender apartheid, as Rangita de Silva de Always cited it this morning, as inhumane acts committed in the context of an institutionalized regime of systematic oppression and domination by one gender group over any other gender group or groups. And this is very important, committed with the intention of maintaining that regime. And so this is really the current legal understanding, international legal understanding of gender apartheid that we hope to see codified. And Elisa will talk much more about this. So where did this concept come from? I think it's really important to note that women's organizations, in particular in Muslim majority countries, have been using this concept to describe fundamentalist oppression of women going back to the late 1980s and the 1990s. And I remember hearing about this as a young feminist. My family is in part from the North African country of Algeria, and the Algerian women's movement was talking about this concept back in the 1990s as being a way of describing what the fundamentalist armed groups that were fighting in that country at that time were trying to impose on women. But Iranian women were using this concept as late as the late 80s. Afghan women were using this concept in the 1990s when the Taliban were in power the first time. And I think it's no accident that the first person to use the concept of apartheid to refer to the kind of regime that I described the Taliban to be was indeed himself from North Africa. It was the late Abdel Fattah Amor, who was the rector of the law school at the University of Tunis. So he himself was from a Muslim majority country with a fairly liberal approach toward women's rights. And he understood that what the Taliban were doing was not just a question of culture or religion, it was political. It was about their ideology. And you'll see here that he said, this is in the 90s when the Taliban were in power the first time, that the Taliban have introduced what is in point of fact a system of apartheid in respect of women. And he referenced some of the very things that I was talking about are happening again now: exclusion of women from society, employment, schools. And he, I think this is translated from the French, it sounds a little odd to us in English, the word choice, but he said that basically the maintenance openly and publicly of an apartheid policy of this nature is abnormal from the standpoint of human rights, by which I think he really meant sort of unacceptable. And I think absolutely critically important to understand this history. This concept of gender apartheid is not a Western invention at all. And what we are now trying to do in the work today is to give an international legal architecture to what has been a feminist campaigning tool over many decades. And this has happened with other concepts in international law before. One thinks of the concept of femicide, for example, or even a concept from another area of human rights, sort of across the human rights field, the concept of disappearance, which again was about a way of reflecting how victims understood their experience even before it was codified in international law. Now, it's been amazing to see. I mean, a piece of the good news has been that since the Taliban returned to power, because of the creativity and courage and relentlessness of Afghan women human rights defenders, there's been a lot of progress in recognizing this concept of gender apartheid in the field of international law and indeed around the world. And it's been very heartening to see some of the support from Southern Africans who themselves had experienced apartheid in the 20th century, including perhaps most prominently here, Graça Machel, the former First Lady of South Africa and of Mozambique for that matter, and a very noted human rights and anti-apartheid campaigner in her own right. Wright, who said back in 2023 that she agreed with this notion of gender apartheid, and that in fact the same vigor should be applied to fight this kind of apartheid as was applied in the case of South Africa. And there's also a letter sent by a number of leading South African judges, lawyers, and human rights advocates supporting the codification of gender apartheid back in 2024. And I see my time is winding down. So I think what I'm going to do very quickly, here's the UN Special Rapporteur on Afghanistan. I could say more about his work in the discussion, but he has very strongly endorsed the notion of gender apartheid and actually has said that in his consultations with Afghan women, this is the concept that he finds they see as most reflecting the transgenerational harms that they have experienced. He has endorsed both recognizing the concept of gender apartheid as an interpretation of apartheid, but also the codification of gender apartheid. And I'm going to skip through this. We can come back to it if anybody's interested. But I want to end quickly with this question of added value. So why do this? We have a CEDAW convention. We have some other concepts in international law that are also very important, like gender persecution. What is the added value of the apartheid approach? First of all, I think it's very important to note that apartheid is an international crime, and the prohibition on apartheid is understood as having a very strong standing in international law. It's also, to quote one of the Afghans I interviewed, a powerful mobilizing tool, and it's one of the only tools we have that allows us to put pressure on governments, international organizations, and transnational corporations. And I know this is an important topic for Professor Green, in terms of making sure they do not engage with the Taliban in ways that show tolerance for and help perpetuate grave abuses. And we also hope that the concept of gender apartheid strengthens the pariah status of the perpetrators. It's really a kind of a bulwark against the normalization of perpetrators. Remember that apartheid South Africa was ejected from the UN General Assembly ultimately, and it was the African National Congress, their opponents, the government's opponents, that had observer status. And finally, I think the apartheid concept also elevates the international status of the opponents of gender apartheid. So in addition to, I think, best characterizing what is actually happening to women, as I described at the beginning of my remarks, we get these advantages as well from the recognition of and prohibition of gender apartheid. And I think also a recognition that this is a political issue. There may be religious and cultural dimensions of it, but at its heart, it is a political issue. And I think surfacing the political nature of the question of women's rights is critically important in international law. So I have about 1 minute left. Let me just skip quickly to the ways forward. And I'm really only going to talk about number one, because Elisa is going to talk about number two, which is critically important at the moment and very urgent. So in terms of ways forward, I think there's a number of things we need to do. One is to try to coordinate all the diverse efforts to promote the concept of gender apartheid internationally. I don't have that on the slide. Another is to use existing apartheid conventions and standards now with a forward-looking, gender-inclusive interpretation. And just to give you an example, I did this when I was a UN Special Rapporteur back in September of 2021, where I issued a statement with other experts when the Taliban had banned women and girls from participating in sports. And what we said was that the spirit of the Convention on Apartheid in Sports should apply to that ban, even if the letter of that convention did not, because it defined apartheid in racial terms. And one of the ways that we're trying to advance these sort of forward-looking interpretations at the moment is by developing an experts declaration on gender apartheid, which I can say more about later. I have been working on that with Afghan and international colleagues for close to a year and a half now, and we're hoping to see that adopted to really push forward this idea of using existing law while we are waiting for codification, as well as supporting codification. So I think I remain very inspired by Afghan colleagues, and you see some Afghan women human rights defenders at a recent ASIL meeting here who have simply not given up, and they really deserve an effective international response. And I truly believe that one day they're going to put an end to Taliban repression of women. But the real question is, will they do this with the help of the international community, or will they do this in spite of the international community? And I think that is what is going to determine how long it takes. We owe them a principled and robust international response. And I think if business as usual continues, we're going to see really devastating consequences on the ground in Afghanistan, but also throughout the region and for women's rights everywhere. And I think of something Antonio Guterres said at the UN Commission on the Status of Women. He said, those of us who care about equality for women have to stand up and speak now because the masters of misogyny are on the rise. And that's certainly true here too. And I think Afghan women know better than anyone how important it is to heed the Secretary General's words. That is to say, to stand up and speak up for women's rights now. And I think a critical way of doing that is in supporting the gender apartheid approach. Thanks a lot.
Thank you so much. And Karima did such a great job, I think, setting up for my turn. So I really appreciate that, Karima. It's really great to be here. I am a visiting fellow here, but I haven't been back in a few years. So it's really great to see some familiar faces and just return to campus. And I just want to thank the Human Rights Center and MJIL for having us and bringing us together for this really important conversation. So as Karima mentioned, I do want to focus my own remarks on this particular movement to legally recognize and codify gender apartheid as a crime against humanity under international law. And I'm going to focus on that through the lens of what has been launched as the End Gender Apartheid campaign. So this was a campaign that was launched in 2023 and has really become part of a larger movement driven by a coalition of Afghan activists living in exile and inside Afghanistan, together with other global feminists and human rights activists, anti-apartheid experts and jurists, as well as UN experts and member states. And we are largely animated by the deteriorating situation in Afghanistan, which you've heard a lot about today from Karima, as well as from Rangita earlier from the CEDAW committee. And I just want to focus, I think we've covered a lot of those strands. I just want to give a quick recap of the breadth and maybe the institutionalized nature of this systematic gender-based oppression and domination that the Taliban has put forward. So Karima mentioned, 130 agreed. It's a bit of a controversial number. I will say that one of the Afghan partners I work particularly closely with, who has launched something called the Afghan Justice Archive, has said 200 decrees, laws, and policies. But whatever it is a disproportionate amount of what the Taliban has been regulating and issuing by law and decree has specifically been targeting women, girls, and I should include LGBTQI plus individuals. And maybe that's an angle we're also happy to cover later. Many, have heard and are familiar with the ban on girls' education after grade 6. I think Karima also, really alluded to the breadth well beyond just education, right? So women and girls are being prohibited from showing their faces outside of their homes, from singing, reciting, or reading aloud in public. And I should say that includes reciting the Quran, from traveling anywhere without a male guardian, and from working in most sectors, including in government and NGOs, and most recently, including a ban on even UN female personnel and national personnel and contractors from entering UN compounds. So they are being precluded from even doing the work that the UN is trying to do to, frankly, keep what is a compounding human rights and humanitarian crisis at bay. Two observations about this regime of systematic gender oppression. The first is really the increased granularity of the Taliban's decrees, and I just want to get into that in one moment. And the second is their legal entrenchment and enforcement. So this first point, what really started as sweeping restrictions on public life and public participation have increasingly become granular. They are moving into every single aspect of one's private life at home. And I should say that includes women right now being prohibited from being visible through windows into their homes. I think about this every time I cook for my family. I have a window that faces a public street. this would have to be boarded up right now. And if it was a new build, you would not even be allowed to have a window in that kitchen. The recent January so-called penal code legalizes domestic violence. It permits men to beat their wives unless their bones are broken or their wounds are open. This is a dystopian ambition of Taliban oppression. This second point I wanted to turn to is, this legal entrenchment and ongoing, I will say, punitive enforcement. So what started as disparate and oftentimes inconsistent, I should note, decrees and policies. So across provinces in Afghanistan, you might see, it's being enforced in one province, it's not really being covered in the next. Over time, that has become completely totalizing and entrenched, with the further formalization of decrees through laws like the Law on the Promotion of Virtue and the Prevention of Vice, and the Criminal Procedure Code, the Penal Code that I just mentioned. To be clear, nobody escapes from the dragnet of oppression and enforcement. So it's not just that women and girls are impacted, but men in their lives are also being forced either now to enforce what this regime of systematic oppression is requiring, or to themselves be detained and punished for their resistance. And, one particular element I keep thinking about is fathers in this space. Their daughters now, who are basically under the custody of their husbands, are not allowed to have their daughter visit them in their home unless that husband gives their permission and consent. This is how draconian the current regime is. And it is the dystopian, the deliberate ambition, and the totalizing institutionalized architecture of the Taliban's gender subjugation that really distinguishes gender apartheid from gender persecution and gender discrimination. It is what the International Law Commission, when distinguishing between apartheid and persecution, said it is that institutionalization, that legal mandating of the system that is distinct. So in this respect, the End Gender Apartheid campaign has really focused on two strands of advocacy. The first is political, and that's to recognize the situation in Afghanistan as gender apartheid, call it what it is, and use that as a tool, as Karima said, to resist normalization of relations with the Taliban regime, especially as we're seeing increased backsliding across the multilateral system. The second is legal advocacy, and that will be my focus today. Just because we are at the law school and you are all budding lawyers, I really want to focus on this codification effort, specifically to recognize gender apartheid as a crime against humanity in the Crimes Against Humanity Treaty. And I do want to be clear, and I think Karima, you said this before, this is of course animated by Afghanistan as a paradigmatic example, but it is not alone about Afghanistan. You cannot prevent and punish what you do not name. And if we fail to act now to fill this accountability gap, we are basically giving the green light to other regimes to similarly perpetrate gender apartheid. And many of our Afghan partners have often asked us, had gender apartheid been criminalized after the Taliban's first rule of Afghanistan, would we be facing the same atrocities being perpetrated today? And I think not. So there are several pathways for codification. If this were more of a Socratic method, I might have opened this up and asked others, what those might look like. Mackenzie, I was looking at you and debating calling on you, but I won't put you through that. So there could be an intergovernmental treaty, right? Something specifically dedicated to gender apartheid. It could be an optional protocol to the Apartheid Convention. There could be an amendment of the Rome Statute. What we have focused on is the Crimes Against Humanity Treaty. And frankly, that's because of expedience. This is the process that was already being underwent at the UN Sixth Committee, the legal committee at the General Assembly. And we realized, this is actually a very obvious way to enumerate gender apartheid as one of the definitions in the Crimes Against Humanity Treaty without having to open up, for instance, the Rome Statute and gather all that political will that would be needed for such an amendment. I'm just curious, I know Professor Leila Sadat was recently here and spoke on the Crimes Against Humanity Treaty. Did anybody in this audience attend that lecture? Okay. So some of you already have the baseline. Maybe I will do just like a quick recap of what this treaty is for those who are not maybe as familiar. And this is the first UN treaty on core international crimes since the Rome Statute of the ICC. So that's since 1998. And I would just underscore how historic this treaty is. It's really 80 years in the making since crimes against humanity were prosecuted in Nuremberg, and yet they are not actually in a dedicated treaty. So as you all know, we have a treaty on genocide with the Genocide Convention. We have a treaty on war crimes, or treaties, I should say, with the Geneva Conventions, but there is no dedicated treaty on crimes against humanity. So the purpose of this treaty is really to fill that gap. And I will just say, frankly, the very fact that this treaty is moving forward and moving forward by consensus, in fact, at the UN is pretty remarkable given all the other dysfunction and geopolitical tensions we're seeing strain the UN system. And I'm very happy to talk about, why we think this is still able to move forward at this current moment, despite all those realities. But let me turn to the specific proposal, and Karima put it forward. This is the same exact language that Karima had highlighted. These are the core two definitional elements that we see of gender apartheid, drawing on the definition of apartheid in the Rome Statute. And that's first, and you'll see them highlighted, is the context of an institutionalized regime of systematic gender oppression and domination. And the second is the intent to maintain such a regime. And I should say, to get even more in the weeds of the drafting process and our discussions with member states, we've also put forward two specific pathways of how you can get to that. So one would be, I think as Karima mentioned, you can open up apartheid, amend apartheid to encompass both gender and race. I will say that has garnered particular support from South African feminists who have long asserted that gender was an additional, albeit secondary, axis of apartheid in Southern Africa, and yet international law, including the transitional justice processes there, have not sufficiently recognized those gender dimensions. So the idea would be to have the same definition, racial group over any other racial group or groups, or gender group over any other gender groups. The second option would be to enumerate a new crime, so a new kind of sub-article that just has this definition here as a separate crime of gender apartheid. One of the reasons we introduced this second option or consideration was actually in light of some of the pushback we are getting on the sensitivities of the term apartheid and its racial origin. So I did think it would be interesting, maybe from a student perspective, to talk about the types of tensions and pushback we get on this gender apartheid proposal. And I'll be honest, when I joined the team in 2023, and right before, I knew I would be mainly working on the End Gender Apartheid campaign, I asked some legal scholars, some colleagues of mine, some diplomats that I used to work very closely with, and they were all like, absolutely not. Like, that's never going to happen. Complete skepticism. Both the term gender and apartheid, both are so sensitive right now in the multilateral system. Like, good luck. I would like to say, and thanks in large part to Karima's leadership and that of UN experts and others, we've moved, I think, well past that skepticism. So there are a number of UN experts. Karima highlighted the special rapporteurs and special procedures. I would also just want to highlight how vocal the High Commissioner for Human Rights has been on the need to codify gender apartheid. And most recently, the Secretary General, in his Commission on the Status of Women annual report, actually identified gender apartheid needs to be codified in this treaty to fill what he sees as a lacuna in the law. Not only do we have the support of UN experts, but we also have now to date 12 member states that have at least expressed openness to gender apartheid. I want to just underscore how important it is that this is a cross-regional group of states, and that's something we've really underscored. To Karima's point of the term, originating in a grassroots and non-Western active group of feminists and activists, we also want to make sure we kind of recognize the also decolonial origins of the codification of the crime of apartheid, right? So that this is all coming from that broader global majority-driven movement. And I will say part of the reason we've, I think, been able to secure a lot of this success is because we're embedding it as part of a broader movement, which is to ensure that this treaty writ large is gender competent and gender inclusive, that it's intersectional, that it's survivor centered. So I'm not going to go into these in detail since I think it's beyond maybe the scope of this panel, but I do just want to say, the ambition here is we're not just going to update the provisions of the Rome Statute, which are the baseline of the treaty, to reflect recent developments in international jurisprudence. I think we also want to be bold. We want to think about what does progressive development of the law require for us to actually respond to the lived realities of survivors, not just today, but also in the future. What is required to future-proof this treaty, looking for 25, 50 years from now in evolving and emerging harms and modalities of harm. I did want to just flag one, though, because we had the excellent remarks earlier on obstetric violence. So I wanted to flag that there is a proposal right now to include reproductive violence. And a big push on this is really to ensure we're covering and broadening beyond the explicit acts that are currently recognized in the Rome Statute, which are forced pregnancy and forced sterilization. So depending on the formulation here, and I've seen it as kind of the deprivation or, some sort of violence against your independent reproductive autonomy. This could include forced abortion. It could include forced contraception, the forced suppression of breastfeeding. So really interesting, and I will say a progressive push. And I want to flag that that's really being led by Palestine and Colombia, given the acts of reproductive violence that they have seen in their own homes and their affected communities. The last point I guess I would just make before I close is that why do we need all of these names? So the previous panel with Fanula and with Anthony was, there were some questions of what is the point of enumerating all these distinct legal harms and interests? And I just want to really underscore how important it is as part of a survivor-centric approach to actually be naming, preventing, and punishing what you see as distinct legal interests that need to be protected. So I often think of the example, the crimes of rape, forced pregnancy, and forced marriage. Why do you need all those crimes? They might all involve the same underlying act of sexual violence. But it's because they're distinct interests. You have sexual autonomy, you have your reproductive autonomy, you have your relational autonomy. Each of those deserves recognition and protection. So similarly, gender apartheid, we often get asked, why do you need gender apartheid? You have gender persecution. Isn't that enough? Especially I will say from male counterparts who ask, women, you are always pushing for this gender thing. Like why you finally have gender persecution. You have all these other, potential sexual violence, like just stop complaining effectively. And I will say I've been told that pretty bluntly at the UN. But it's for a reason, right? There's a distinction between gender persecution and apartheid, as we've discussed already. And there is no crime right now that actually captures that institutionalization of systematic gender-based oppression and domination, nor, I will say crucially, that dystopian intent to maintain a regime completely rooted in subjugation. So I will say we do deserve that, and we are working, I will say, to build on the incredible work of our four mothers, I like to say, in the feminist movement. So looking at the lessons learned from the feminists that were able to codify forced pregnancy in the Rome Statute in direct response to the horrific atrocities perpetrated in Bosnia and Rwanda, or looking at the decades-long fight by feminists to get rape recognized as a distinct crime under international law rather than letting torture be a catch-all. So there's such an importance, I would say, in having kind of this conversation of what does it actually require to encapsulate the totality of harms that women, girls, and LGBTQI individuals are experiencing. So just before I'm out of time, the last slide, this is just where we are now in the process for the treaty. So we're at an incredibly urgent moment. And I've been anxiously watching my WhatsApp and Signal throughout the symposium because a lot of states right now are drafting their textual proposals for this treaty. So we'll find out by the end of this month whether in fact there is a group of states that are putting forward gender apartheid. I will say I am quite confident that there will be at least a handful, at least that I've spoken to. Same for those other gender-based proposals I was showing on the prior slide. We then move into the next year, and as you all know from taking international law, this is a long process. So the negotiations don't begin until 2028. It's possible that they could be extended to 2030 for a third year, but they will at least require 2 years of negotiation. And we'll see. We'll see if gender apartheid does in fact get codified here. I will just say, my last word of kind of optimism, whatever happens, the very fact that gender apartheid is already in the negotiating record because states have been calling for it to be codified means that it's already part of the travaux and drafting history of this treaty, which means it's part of the normative development under international law. And hopefully, we actually see this codified in the coming years. The last very quick footnote I will say, 2030, we were all as civil society very actively resisting an extension for another year. We're like, 3 years, oh my God, we're all going to be like in different jobs by then. Who knows what the reality will be? And the Taliban, who knows what will be happening on the ground by then? And it was very hard to manage expectations with our Afghan partners in particular. 2030 now, frankly, many of us are thinking maybe it will be a different geopolitical climate. Maybe, in fact, this is the best thing we can ask for is like we pause, we draw this out as long as we can, and we have a different administration with potentially less backlash on anything gender or race related. So, jury's out, but we'll see where we land. And I'll stop there for now. Yeah.
I'm going to open it up to questions. So there's been a number that have been kind of teed up by both Karima and Lisa. So If you want to any of those particular questions, great. You have your own, also wonderful. And if not, I'll ask my, yeah.
My question is for both of you. Thank you for leading. So I've been aware of this, the gender apartheid campaigns, the campaign to include gender apartheid into crimes against humanity.
We're gonna ask you to use the mic.
Great. Somebody should tell my mom she was shocked that I was not 100% by her. Is it working? There we go. Now it's working. That's happened to me twice now. Okay. So I've been aware of the campaign for quite some time. One of the things, so I completely agree with everything that you said, Elisa, about kind of this, you didn't use these words, but what I understood to be the expressive function of having gender apartheid on the books in international law to kind of reflect, the international community's recognition that there's a particularized kind of harm that's happening in Afghanistan and in other places in the form of gender apartheid. I'm curious, so one of the major advantages, of course, that we've been told about, and I completely agree with it, about having the Crimes Against Humanity Treaty on the books is that it opens up the possibility for universal jurisdiction cases in a host of jurisdictions, especially in situations in which, crime against humanity, which is by far the most the largest and widest encompassing core atrocity crime on the books at their own statute, might be taking place in jurisdictions outside of the ICC's jurisdiction. And so one of the things that eludes me, though, and so I'm curious to hear your thoughts about this, is what the proponents of the gender apartheid, of including gender apartheid in the Crimes Against Humanity treaty would imagine to be kind of like the base underlying acts that could be prosecuted in universal jurisdiction cases. So I imagine, for the rest of for the other crimes against humanity, there's very obvious base crimes, because they're physical acts, they're interpersonal harms. But what kind of participation in a governmental structure? Is it passing legislation? Is it high leadership? One of the advantages, of course, for universal jurisdiction cases is that it allows jurisdictions to prosecute low-level perpetrators. So what kind of a low-level perpetrator could we imagine to be prosecuted in universal?
Running a little tight on time. Yeah, we're gonna do a couple and then.
Hi, can you hear me?
Yep.
I had a question in particular about the codification of gender apartheid as to the second element of intent. So what's the motivation behind that? Why include that? If you could perhaps encompass regimes that have these specifically targeted pieces of legislation or practices that maybe don't intend but could still be swept in. I'd just love to hear the justification about that specifically.
One more back.
If this is, sorry. This may be a particularly long one, so if it's for the end, that could be whatever. But a lot of international legal scholars have affirmed that separating countries from international legal systems are not necessarily an effective way of making them engage with international law. However, the South African example regarding racial apartheid has shown that actually sanctions and suspensions can work to change internal legal systems. My question is, given the current situation of the Taliban, is the strategies being proposed nowadays a complete rejection of dialogue with that government until the situation on the ground changes? Or is there some level of partial engagement that is being proposed to more effectively mitigate damage as soon as possible? And I recognize that talking about damage mitigation and crimes against humanity is horrible, but I understand that it's also kind of a necessity.
Sure.
Please start.
So on the universal jurisdiction case, I think you're asking, what would the inhumane acts be as part of that understanding? I mean, of course, you could do the obvious ones, which are in fact happening, which is murder, torture, or sexual, rape, etc. Gender persecution could be actually one of the other, although that also requires yet another loop to another underlying act. And I will say there's a concurrent effort that I forgot to list, I think, on this, which is to have gender persecution be prosecutable as a standalone crime rather than requiring a linkage to other inhumane act. I think the most interesting part of gender apartheid could be the other inhumane acts being legislative measures or being something maybe what we wouldn't see as discrete acts of violence, but in fact are part and parcel of the institutionalization of this regime. And so we've actually issued a legal explainer that goes through each element of the crime as per that definition that you saw up on the slide, and what we could infer as a potential indicia of each of those elements. And one of those was looking at the Apartheid Convention, that Travaux. I'm looking at how that refers, in fact, to legislative measures as potentially being that underlying act. And I should flag, apartheid has not actually been prosecuted to date. So there is an ongoing case right now in South Africa prosecuting it along these lines of this definition, but we don't know. So we are pulling kind of jurisprudence from other atrocity crime jurisprudence, which is a quite complicated matter. And I will say there are some places where we think it's quite appropriate to liken to other atrocity crimes, and others where in fact it wouldn't make sense to try to infer from a crime with a completely different structure. The intent question, really good question. Part of this is that we were looking at the Rome Statute definition, which has intent as a core element of apartheid as it stands. And I do think, even though, and interestingly, the International Law Commission, when it did codify and talk about the crime of apartheid in the draft code of crimes, they actually don't mention intent as a distinguishing element, which I think is really interesting, because to me, the first thing I thought, and maybe it's too much of our exposure to genocide, litigation right now, but the first thing I thought was, oh, wow, okay, so this is very distinct. It's a very high legal threshold. It probably would require, frankly, a specific intent element. And something we've been very careful to say is, no, let's not raise the threshold unnecessarily. There is an intent requirement. I've been likening it to like a general intent threshold. I'm looking at Article 30 and other jurisprudence on that. And I think on the sanctions question, I will turn to Karima.
So first of all, I wanted to say thanks so much to the organizers for giving us this amount of time to talk about gender apartheid, which I think is really sort of a testament to the progress that we've made getting this issue on the agenda. And I thought those were three really excellent questions and really comprehensive answers already from Elisa on the first two. So I won't say much about them. I would say one thing about the drafting, with great respect to the people who are leading on that. My view has always been that the fewest changes that we need to make to the definition of apartheid would give us the best chance of succeeding with codification. But you're right, there's also some cost to that potentially, but I still think the chance to get it through really is based on making as few changes as we can. So I think that's a key part of the choice around that. So this brings me back to the engagement question. This is a really difficult question, but let's look at the South African example, not because I'm arguing that it is the same as the Afghan context, but I think there's a lot we can learn from the international response to the situation in South Africa. And so if you cast your mind back to the 70s, the 80s, the Reagan administration, the US and UK governments at that time are pushing something called constructive engagement with apartheid South Africa. Stop sanctioning the South African government. You're going to push them away. It's not constructive. It's going to hurt their economy, our economies. And the rest of the world is saying, absolutely not. This is beyond the pale. This is discrimination as the governance model, which is no longer tolerable in the late 20th century. And we have to show a unified front internationally to stand up to this form of governance, to show our opprobrium for it. This is how you get apartheid South Africa then ejected from the General Assembly, and you get the sanctions that are imposed via the Security Council and other measures that are taken. You get extensive creation of sort of UN mechanisms. There are many UN mechanisms. There's a special committee on apartheid. There's all sorts of sort of time and space given to civil society in the UN system that is pushing back against racial apartheid. And it's time, I think, for international law to learn from its successes. Look what happened. I mean, there are still ongoing human rights challenges in South Africa, but de jure racial apartheid was defeated because there was a very sophisticated set of movements at home working against it, who were then supported by parts of the international community and the UN system. And I would argue that is the model that we need vis-a-vis Afghanistan. Now, does that mean there can never be any engagement with the Taliban? I will say that is a very controversial question amongst our Afghan colleagues. My view, and I think the view of a number of the colleagues, international and Afghan, that I work with on this question is the following, and that is that there cannot be engagement which shows tolerance for or perpetuates grave abuses. So we have seen some of this. Governments sending all male delegations to meet with the Taliban and then posting on social media these delightful pictures of these all male discussion groups basically talking about the situation in Afghanistan with no mention of the situation of women's rights. Or say the UN holding the Doha process in which the Taliban demands Afghan women can't even be in the room and their rights can't be on the agenda. And the UN, perhaps for good motives, says yes. These kinds of engagements do grave harm to Afghan women, to the morale of Afghan women, to the morale of Afghans, and I think make normalization sort of ever more creeping forward. And so for me, what I really want to see is human rights-based and women's rights-based scrutiny of any proposed engagement with the Taliban. And I'm sorry, were you trying to tell me we're out of time? No, okay, yes, oh, you were, okay. Sorry, and now I lost my last thought. The tricky piece of all of this, which is quite different than the South African situation because of the different sort of economic nature of the two countries and the two regimes, is the humanitarian situation in Afghanistan, which is very grave indeed. And so many things get justified in the name of needing to provide humanitarian assistance. Some of that need is indeed very real, but sometimes that is also used, I think, as a justification for forms of engagement that are really unhelpful. And I think what we need to see is a really integrated approach in which human rights and humanitarian action are recognized as really interlocking. And in fact, if you don't deal with gender apartheid, which is keeping women, for example, from working and gravely harming Afghan families and the Afghan economy, it's going to be impossible to actually solve the humanitarian situation. But you're right to flag this issue because it isn't an easy one.
My follow-up question, and this might have been part of where you're going between them, but we might get more involved. And the pitch to action.
The pitch to action, one I would say is for anyone who's in a position to do so, as Elisa already mentioned, call the situation gender apartheid now. We need governments to do this now. We need to be pressuring various governments to do so. It's very important also to support the work of Afghan women human rights defenders, bring them here to speak to you, read what they are writing. There's a whole literature now, there's many graduate students from Afghanistan who are writing dissertations and so on gender apartheid. I think very important to highlight those voices. And if anybody is interested in getting involved in the work on the Declaration on Gender Apartheid, which we very much hope can be perhaps adopted by August 15th, which will be very tragically the 5th anniversary of the second Taliban takeover. Anyone interested in working on that, please let me know. And just to say very quickly before handing over to Elisa, so experts' declarations in the past, you may be familiar with the Yogyakarta principles, have made huge contributions to pushing international law and human rights law specifically forward. And what we're hoping is to do that with this declaration, basically affirming a lot of what Elisa and I said, recognizing the concept of gender apartheid, calling for codification, calling for forward-looking interpretation while we're waiting for 2029 or 2030, because Afghan women cannot wait. And anybody who'd like to get involved in that, please let me know. And I'm sure there's a lot of to-dos on codification.
Yeah, I mean, echo everything Karima just said. I will say for students particularly, we're really interested and frankly just don't have the capacity to think about what an international students movement would look like around this. I want to really underscore the last thing we want is this to be a US university-led initiative, just given how important it is that we make sure this continues to be kind of global majority driven. But if there are associations, I'm honestly not remembering from my now almost decade years out of law school, but if there are any of these like cross transnational associations, and this might be of interest, like please continue keeping the drumbeat alive. Also consider getting involved on the treaty writ large. And I will say, you know, this codification movement, it won't make a difference if we don't maintain the universal jurisdiction provision, if we make sure we're really protecting against overly broad immunities provisions, if we're not thinking about kind of the third state responsibility and potential ICJ dispute settlement provision. So there are so many angles for anybody here who is more interested, I think, more broadly on the architecture here to ensure that this is enforceable in the end.
Great. Thanks, everybody, for the great question. I'm going to turn it over for David.
Just a very brief but sincere thank you to our speakers, to our moderators. Taking time out of all your work to come and join us here on campus and online means a lot. This exchange of ideas, I think, for students, but for all of us to hear the debates from the experts that are working on these front lines, what's happening, how it's working is really a privilege. So grateful to all of you, to Anthony also. Everyone that joined us online and here on campus. We're in our own moment of thinking about how international law relates to all different kinds of justice struggles, and it is just great to have this time together thinking, and so I appreciate you all taking time. Thanks to the Journal for letting us all be a part of this and join the conversations, and a special thank you to Abby for making it all happen. So thanks, everyone. We'll see you at the next one.